All right, let's explore this issue further now and speak to Professor Pierre De Vos, who's the chair of UCT's Constitutional Governance at the Claude Leon Foundation. Prof, always a pleasure to speak to you. This matter, she's indicated through that state attorney's, the letter she sent to the state attorney's office, that it's likely to go back to the apex court, the same court that dismissed her application last week. Is this procedurally sound?
No, actually, it's a complete abuse of the legal process. There is no, you can only make a rescission application if there was a court judgment in which a serious, egregious mistake was made. Here, there was no judgment. The court declined to hear the case. They said there was absolutely no prospect of success because the grounds were, for whatever reason, my interpretation is because the grounds was really an attempt to appeal the judgment of the same court to the same court. So I don't understand how there can be another application. There's no provision for it in our law. It has never happened in the history of South Africa. So I really think that she and a lawyer should think before they proceed with this, because it is clearly an abuse of the process to stall the impeachment procedures that is continuing in the National Assembly.
Prof, at the same time, she wants Parliament to hold off on pursuing its investigation into her fitness to hold office. Now, listening to Mbegazeli Benjamin from Judges Matter, he says that the fact that there's a criminal case now which relates to that particular SMS does not have a bearing on the process of Parliament. Is that your understanding as well?
Yes, that is obviously correct. Mr. Benjamin is correct in this sense, in many senses, but in this sense that the procedure before Parliament is proceeding because the Constitutional Court held that all the objections the Public Protector previously raised were not legally valid. Whether there was now a leak from the Constitutional Court, which we don't know, doesn't change the fact that the court said there is no case, it's dismissed, it's the end of the road. Whether there is criminal charges, even if Mr. Abramji is prosecuted, it has absolutely no bearing on whether the proceedings in Parliament can continue, because the Constitutional Court has finally confirmed, and it cannot be overturned, and it will not be overturned, that the procedures are constitutionally compliant.
And I'll get to the SMS again, Prof, in just a moment, but I'm keen to find out then, what does it mean for that matter that was postponed in the Western Cape High Court now? Is it going to go ahead, or is that case now moot, essentially?
Yes, I think, again, I agree with Mbegazeli Benjamin that that whole case was based or premised on the idea that there will be a rescission of the original judgment of the Constitutional Court. That has not happened. There is no rescission. It cannot be revisited. And so the High Court cannot overrule and second-guess the Constitutional Court because it's a lower court. So I would think that the whole application has now become moot, that it cannot proceed, or if it does, it won't be successful. Yes, so unless and maybe another application will be brought, but this one I think is going to be difficult to see it proceed in the coming weeks.
Let's talk about then another layer to this, because if you look at the Act and the Constitution, she can be suspended by the President pending the outcome of the investigation into her fitness to hold office. So I'm going to ask you a question that is two-pronged. Can the President now suspend her? And looking at the fact that she had indicated that should he do so, because he's a conflicted party, there might be protracted litigation. How far do you see this one going?
Okay, so the President could have suspended the Public Protector the moment that the National Assembly decided to proceed with the impeachment inquiry. That is clear from the Constitution. The Public Protector say that the President is conflicted. There is maybe an argument to that. So if the President can proceed to suspend her, and she can then go to the court and challenge this. Whether it will be successful, I think the President will probably win, because a reasonable person wouldn't think in the present context, with the present fact, that the President is conflicted. But some courts might disagree, so there's a chance that that challenge of the suspension could be successful, but that doesn't mean that the president cannot proceed if he has legal advice that advises him that he is not going to be conflicted, to suspend and then take the chances in any court matter that might come up in the future.
So, Prof, I'm going to ask then a question that, could look at the future, because her term expires next year. She has indicated in various media reports and has also told us on the show that she will finish her term come 2023. Given these delays, how do you think this inquiry is going to proceed, if at all? Or do you foresee it being litigated then or interdicted before proceeding even?
My personal view, assessed on the facts, is that if the Parliament and the President decide to ignore the various attempts to use the courts to delay the process, and they just proceed and then court action will happen, the chances that the Parliament and the President will lose are slim. So if they decide to ignore these attempts, it will probably conclude, and then we will see if the National Assembly vote with a 2/3 majority or they don't get a 2/3 majority to impeach. But of course, if they agree to delay because of the court action, then we know from other cases that people with very deep pockets who can pay lawyers can use procedural arguments to delay a matter almost indefinitely. So that is an option if the parties agree to delay because there is pending court action of some sort.
So, Prof, I'd like us to look at this SMS issue because it has thrown the independence of the judiciary debate once again into the spotlight. And I saw recently News 24 reporting that the Chief Justice is apparently aware of the fact that Mr. Abramji recently hosted an event to celebrate the recent appointment of Constitutional Court Justice Mkhwebane, and they're seeking clarity about that particular engagement because they're saying that even the, acting Justice Dunstan Mlambo is said to have attended that event. Does this also not further fuel the fire when it comes to some of the issues around the independence and even her arguments that there appears to be a collaboration or collaborated effort against her?
Well, of course, people who don't understand how the system works can easily be persuaded that there's a problem. If there was a leak, it is shocking and outrageous because there should be confidentiality about decisions taken by the Constitutional Court until they are announced. So if there is a problem there, it will be really a big problem. But it has nothing to do with the decision to reject the rescission application. Even on the version of the public protector, the decision to not consider the rescission application was taken before the leak. So it doesn't really implicate the judges in anything except if, and one doesn't want to speculate, if the allegations are true that a judge might have spoken out of turn before the decision that they had already taken was announced to the public. That would be a problem, but it doesn't actually say anything about the decision or whether the public protector was treated fairly by the Constitutional Court. But because there's already contestation around the courts, it does pose a threat to the legitimacy of the court because people who do not understand the system are going to think maybe there is a conspiracy going on or whatever the case might be. Yes.
Prof, as we round up this conversation, I'd like to pick your brain on this one because when I read most of the articles around this particular letter that has now been written to the State Attorney's Office, it talks about her wanting an investigation into the charge, of course, around Mr. Abramji. At the same time, she says there's a Constitutional Court person who is based there who has not been identified at this stage, who may have unlawfully and intentionally gave or even expected gratification to that effect. There's also the inclusion of, the advocate for the Speaker, Mr. Advocate Breitenbach. There's also the Speaker and the chair of this Section 194 committee. Some have said that this might be an indication by her or an insinuation that there's a collaborated effort by these individuals to a certain outcome. Would you agree?
Now, what I would say is that it is shocking that she has made the allegation, given the fact that there's absolutely not 1 ounce of evidence for this. So obviously, if there is evidence, if the public protector has evidence, she has a duty, a legal duty, to reveal this evidence. She hasn't done so. And as an officer of the court, as a lawyer, you are not supposed to make allegations that you know is untrue or that you have absolutely no evidence for that it is true. So I think it is highly problematic that the public protector has written that letter, unless, of course, she has evidence and she's refusing to reveal the evidence as she is required to do.
Prof, I suspect that we're in for quite a long time here to see how this matter eventually does play out. But thank you so much for your time this afternoon. That is Professor Pierre De Vos, Chair of the UCT's Constitutional Governance at the Claude Leon Foundation.